Did you know you can bypass rent with just a little creativity? Get ready for some next level nonsense. Introducing Sovereign Housing Agency, where paying your mortgage or rent is purely optional. Signed a lease but decided you'd rather not pay? No problem. Our expert team will show you how to file endless, frivolous motions, declare your property as tribal land, and insist that the courts have no jurisdiction over you. Fed up with eviction notices? Just ignore them. At Sovereign Housing Agency, we turn every legal loophole into your personal right. Why move out when you can stay put and live rent-free? Our satisfied customers say, eviction? Never heard of it. And remember, your lease is just a suggestion. So what are you waiting for? Call now and learn how to never pay for your home again. Because it's not just a house, it's your sovereign kingdom. Sovereign Housing Agency. Squatting rights for everyone. Live sovereign, live free. Backed by UCC 1-308 and UCC 1-103. Good evening and welcome for everyone that's been hanging out in the chat already. So I had to switch it up a little bit because some of y'all been like, where the commercial been at? So I threw one in the beginning, but I still got something for you for the end, especially for this case we're about to watch. So this is a case where we have a defendant and he's representing himself, but in the title, he got locked out. He wants to bring some arguments why he think he shouldn't have gotten locked out. But there's going to be a twist in this case. You're going to be like, what? So you'll see, so pay attention because it's going to be pretty good. I watched it earlier. I said, all right, I think you will all enjoy it. So I want to get to it. You know how I do. We have one case tonight, and this is it. And we just going to get into it. All right, and everybody that's in the chat saying hello. Hello to everyone in the chat. You know I'll jump in and out of there a little bit and do what I do, right? But let's get this going. Let's go.
I'm Janine Martin. I'm your court reporter this morning.
Thank you, Madam Court Reporter. I see, is it Ms. Kumbar?
Yes.
And you represent?
Defendant.
Okay, and Mr. Potney, am I pronouncing that correctly?
Yes, ma'am.
And you represent yourself, sir?
I do, yes, Your Honor.
Okay. And Mr. Knight, you're here also representing the defendant, is that right?
Good. Yes, Your Honor.
Good morning.
Morning.
Okay, I'm going to go on the record, Madam Court Reporter. This is going to be a hearing on cross motions for TRO in the matter of Mr. Potney versus Mr. Bimji. Hopefully I'm pronouncing those things correctly, and if I'm not, please tell me. The case number is 25 CV 010452. I'll note for the record that this matter is occurring entirely by video, which is how the court typically conducts its civil docket. It's more convenient for most people to be able to appear. Just as a cautionary matter, do want to let you know that in order to satisfy my obligation to have constitutionally open courts, this matter is being streamed to YouTube. Couple of important points about that. Number one is that is not an official court record. Madam Court Reporter's transcript is the official court record. And so I do want to be clear that although that may be something that you can access online, that no party should believe that that is an official record. And it can't even be, you can't give it to a court reporter and have that reduced to a transcript that can then be used as an official court record. It's merely an artifact of the live stream and often are taken down. So I mention that only so that everyone is aware of that one, we are live streaming, and two, there might be a record of it, but it is not an official court record that can be used going forward. Do also want to let everybody know that I started last night. I spent some time reviewing the voluminous materials that were provided to me by Mr. Potney and also by Mr. Bimji's counsel regarding the background of this case. I have also received emails through my staff attorney of witnesses that the parties intend to call. And before we go down that road, I wanted to ask a couple of questions of both sides, starting with Mr. Potney. Mr. Potney, I understand you had identified two individuals who might testify. You might also testify on your own behalf. Can you tell me what it is that those individuals, if you were, lawyers call it a proffer, right? If I were to say, tell me what it is that you would have those witnesses testify about, what relevant information do you think they would provide the court? Can you tell me what that is, sir?
Sure. Before I tell you that, one of the witnesses, I haven't been able to get in touch with him. He's got heart conditions. I'm not sure. This is the first time I've ever not heard from him, so I have absolutely no idea what's going on with him.
Okay.
That was Andre Maurer.
Mm-hmm.
So he will not be attending. The second individual is Charlie Gonzalez.
Mm-hmm.
He is a real estate agent for Keller Williams. I have him on standby. I'm not certain that I am going to use him as a witness. I just wanted to notify the court that he is ready to testify, and just depending on how the proceeding goes. But
Okay.
to answer your question, I'm sorry. He's a real estate agent for one of the properties that I resided in 2025. And he is familiar with all the claims. He has made contact with multiple parties, including Defendant Bimji and another family member.
Okay.
And he's familiar with all the details of the case. And
Okay, thank you, Mr. Potney. Next question is, so my review of the operative complaint that you have filed and the TRO, the relief that you are seeking is a right of return or possession, ceasing an allegedly illegal lockout of the property at 50. I had it in front of me and now I've lost it. But the address from where you were allegedly wrongfully removed back in 2023. Is that right, sir?
that's correct.
Okay. And as I understand your complaint and the request for temporary injunctive relief, what you are seeking is both a return to possession, some sort of damages action for damage to personal property, and then attorney's fees. That's what I thought I understood from the complaint that you filed in this case. Is that accurate, sir?
Relatively accurate, yes, ma'am.
Okay, thank you. Okay, and today, for purposes of the TRO hearing that we are here for, my review, you have filed several documents that seek interlocutory relief. There was one that was more, lengthier, more detailed. It tracked the outline of the petition that you filed for injunctive relief. That was an emergency TRO that was filed in August, and then a follow-up that was a little more brief on August the 15th. And then you filed a response to their answer and affirmative defenses.
Yeah, that's right. Thanks. I couldn't think for a second. So, yep, that's where she's from. Yep. And yeah, she apparently had an accident. She's doing really good now.
That also sought injunctive relief in December of 2025. And then separately, I have that the defendants filed a motion for protective order and temporary restraining order in January of 26. And then Judge Schwall, who had previously been handling this case, recused from the matter. And then it came to me. And so now here we all are. Is that roughly accurate, Ms. Kumbar? Is that roughly accurate, or Mr. Knight? I'm not sure which one of you to ask.
Yes.
Okay.
Yes, Judge. I'm going to be lead counsel here. Sorry,
Okay.
I'm late, but yes, that is accurate.
Okay. So here, the reason I asked about, and I also, just to make the record fully complete, I understand, Ms., that I had been notified by email to my staff attorney last evening. It was properly copied on everyone that Mr. Bimji might be called to testify as a witness in the case as necessary.
And Judge, yes, possibly, but I think you've already recognized there are legal issues with his request to, I guess, re-enter the property that I think can be dealt with in just legal arguments without even getting into the evidence if this court wants to entertain that, but I will leave it up to you, Your Honor.
The previous tenant is the guy in the left, the top. Well, yeah, the guy in the white shirt up there. That's the one.
Thank you, Mr. Knight. I think you correctly understood sort of what some of my questions were at the outset. Mostly, I just wanted to mention that I hadn't finished that thought of everyone had notified me. This is what they plan to do in terms of evidence. So, Mr. Potney, both parties are seeking a restraining order of one form or another. What are you familiar? I hope you understand that because you are representing yourself, and legally that means I'm supposed to treat you the same as I would if you were an attorney, although I recognize that practically speaking, you don't have the same knowledge base that an attorney would have regarding some of these matters. But you have requested a temporary restraining order, or what we would call in Georgia an interlocutory injunction. Are you aware of the elements that are necessary to satisfy or to discuss and meet in such a request for relief?
I am.
Okay. And so so really there are four elements you have to be able to demonstrate in order to receive, and you don't have to satisfy all of them, but you have to offer evidence on some of them. And it's sort of a balancing of those factors. One of them is a demonstration of irreparable harm. One is that the balance of the hardship of entering an injunction relative to the hardship of not entering the injunction, balancing those equities. The third factor is the likelihood of success on the merits. And then there's this public interest piece. And then in addition to that, there is this other understood piece, which is that courts are not authorized to provide equitable relief where legal relief would be sufficient. And so, Mr. Potney, the reason I'm outlining all this for you is I'm trying to give you some direction about what I think it would be helpful for me to hear from you on particular issues rather than just sort of you starting to talk about everything, if that makes sense. I'm trying to sort of focus what would be helpful to the court if you want me to consider your motion. And really, it's about two things. Number one is in looking at whether or not you have a likelihood of success on the merits, can you tell me, in terms of your claim for possession, what is your legal argument about why you would have a right to claim possession of the property or to return to possession of the property?
Sure. Well, first and foremost, the defendant initiated the civil action with a facially defective power of attorney. He is not a party to the property in any means, to the entity that owns the property. The power of attorney that was used to initiate the dispossessory action had no witnesses.
Hold on. He's here. Thanks for sending the pack over. Thanks for hanging out. I know you'll be on and off, but thanks for coming through. I appreciate you and everybody that came with you.
Right, but my understanding, Mr. Potney, is you weren't actually dispossessed as a result of that dispossessory action, right?
Correct.
I thought I saw in other parts of your filing that basically your argument is that the Mr. Bimji engaged in a self-help eviction without benefit of any dispossessory, right?
Correct.
Okay.
Correct.
Okay.
He was court ordered to revert all the locks and the gate, access infrastructure that he had changed. And he has refused to do so. So whether I want to go back to the home or not, it's not possible.
I've looked at Judge Law's order, and wasn't that order temporarily to allow you to gain access to get your personal belongings out of the house?
No.
Okay, so your understanding was that it was open-ended.
Yeah, well, what happened was Judge Law took notice that Defendant Bimji had simultaneously initiated two civil actions on the same day, an ex parte order of protection and a dispossessory action on April 13th. And when my attorney and myself arrived in court, we kept asking her questions, relating to how is Defendant Bimji being allowed to prevent me from accessing my own home? And she kind of put two and two together. She kind of paused the proceedings, and then she realized what was going on, and she turned to Mr. Bimji's counsel and she said, "You've initiated an ex parte order of protection against Plaintiff or Keyshawn Patney. You have failed to serve him or notify him that there is an order of protection in place. He's been returning to the home every single day without knowledge. Because you have failed to serve him instanter, which is, by Georgia law, an ex parte order of protection that is preventing me from going home." She said, "You need to revert the locks back to their original condition, ensure that Keyshawn Patney can enter and exit the home just as he has done so for the last 10 years. And then she notified me and my attorney that, Mr. Patney, I'm going to advise you that there's a very, very high likelihood that the second you return to that property, Defendant Bimji is probably going to call law enforcement or somebody to have you served. If and when that does happen, and if you do not leave at that moment in time, they can arrest you for violating a order of protection." I said, "Your Honor, thank you for letting me know that. I was not aware. I have no idea that there's an order of protection in effect." They had actually already prevented me from attending the hearing that I was supposed to be at, which was on May 5th.
Okay, let me interrupt you, Mr. Potney, and sort of circle back to. So my question is a little more basic than that. So I understand you started off by taking issue with the procedural legal hurdle circumstances associated with some filings where Mr. Bimji initially started dispossessory action, and then it was you pointed out that the property is actually owned by a limited liability company that I think is controlled or managed by a family member, I believe, not Mr. Bimji. And I understand you take issue with that. But here's what I'm struggling with.
Real quick, y'all. Wolf, thanks for becoming a member. I thought you was one before, maybe. But either way, thanks for swinging back around. I knew I hadn't seen you in a while, so appreciate you coming back.
Typically, for someone to claim a right to possession, they have to have some legal right to possess the property. And I understand that you believe that Mr. Bimji doesn't have a legal right to possess the property, and that Mr. Bimji didn't have a right to dispossess you, but that's not really my question. My question is, what legal right do you have to possess any part of that property?
I was a tenant.
Did you have a lease?
No, it was a tenancy at will.
So did you ever have a lease?
No, never.
Okay.
We've never had a
Did
lease.
you pay rent?
No, there's no mortgage.
Okay. Well, whether someone else pays a mortgage or not is a different question than whether you pay. Because here's what there is some case law that would indicate that a child, albeit an adult child, specifically an adult child, that resides with family members without paying rent and not being subject to a lease is a guest that can be removed at any time. Are you aware of that? I mean, I don't know if that's the answer here, but.
No, I am, but by the owner, right? Correct, Your Honor?
Well, by the people who are authorized to be in possession of the property. In this case, my understanding, haven't seen the contract behind it or anything like that, but my understanding is that the Bimjis are authorized by the owner to be present in the home.
That's incorrect, Your Honor. I can provide documents that substantiate. Opposing counsel they had a deadline yesterday to produce documents, discovery documents. They have provided documents that show highly, a lot of inconsistencies that show that a power of attorney was signed when the LLC was not even active.
Oh, okay. My understanding is that the person who controls the limited liability company is related in some manner to Mr. Bimji or Ms. Potney, who I understand to be your mother and father. Is that correct?
Correct. Yeah.
There it is. When I heard this earlier, my mouth dropped.
Okay.
He's actually the eldest brother.
Okay. Okay. And that I don't know about any documentation, but at the end of the day, there's been no effort to remove them from the home. There's the only information I've seen in all of the emails that you have sent me, and that were sent to me by the Mr. Bimji, is that they are authorized in the loosest legal sense of that term to be in possession of that property. Is that not
These
correct?
documents I just received these yesterday. These were their discovery requests for production. So they just came in last night at 11 o'clock.
Mhm.
And they show a lot of inconsistencies to the greatest magnitude.
Okay. So I guess here's my question. If you are taking the position that you are legally entitled to be in possession of the property, why are they not also legally entitled to be in possession of the property for the same reason?
I'm not saying that I'm entitled to possession of the property. I'm saying that this is a wrongful eviction and an illegal lockout.
Right, but the underlying assumption of you being illegally locked out or wrongfully evicted is that you had a right to be present in the home in the first place. That's what I'm trying to get to. And
Right.
if you didn't have a right to be present in the home in the first place, then I'm not sure that you can insist on a return to possession. That's what I'm trying to understand.
I'm confused as far as I have the documentation of Bimji's own handwritten petition or filing for the civil action stating that I was a tenant.
Okay, and that's something that I may need to deal with, but right now what's in front of me is not the larger legal issue, but the very discrete legal and factual issue of whether or not you are entitled to an injunctive order that says you are allowed to go back into the property. Let me change topics just a moment. One of your claims is for damage to personality, right? So for your personal property. I understood, perhaps incorrectly, and this is your opportunity to tell me, that at some point you were allowed to go back into the property and get your personal property, but that your position is that some of it was damaged or not preserved or something like that. Is that accurate, Mr. Potney?
Yes, ma'am.
Okay. And then other than a right to return to the property and then a claim for damages for the damage to the personality. And then I know there are some damages that you have asserted that flow from your being removed from the house, right?
Mhm.
Are those the main universe of your claims?
I'd say so, yes, ma'am.
Okay. Okay. Thank you, Mr. Potney. I'm going to hear from counsel for Mr. Bimji now, and then I'll come back to you since currently it is your motion. So I'm going to let you have the last word, so to speak, during the hearing. Mr. Knight.
Yes.
Oh, we definitely about to learn more.
Thank you, Your Honor. This case started, it's really just out of, I guess, an attempt for his son to get back his dad. He's done everything in his power to damage his father. This is another abuse of the legal system. He has another lawsuit in the Northern District of Georgia against the city of Sandy Springs, multiple police officers who dispossessed him or removed him, and Mr. Bimji, who also goes by Potney. You're going to see it used intertwined. It's a family name.
The only reason I assumed is because I think in some of the police reports that Mr.
Correct.
Potney provided me, they would refer to Mr. Bimji as Mr. Bimji, but as to Mr. Potney's mother by the surname Potney. And I understand that culturally different cultures follow different naming conventions, and so I just wasn't sure.
So it's a family name, but I think his birth certificate says Bimji, so that's why we felt. I mean, I think that's why he's listed as Bimji.
Okay.
But it is his natural father. They're father son. His son, went to Florida State, worked for ADP, went to Washington D.C., got married, worked for his father-in-law's business. Then Mr. Potney got divorced, In 2013, and had nowhere to go, came back to live with his father in Atlanta. And the key is, Your Honor, is that my client was already living in the house before Mr. Potney, before I should probably use first names, and I hate using first names, Your Honor, but
I know,
Keyshawn,
but in this case, with families, it's easier.
so Vipin and Keyshawn. So when Keyshawn came back to Atlanta, Mr. Vipin was already in the house with his wife, and Vipin allowed his son to live there. His son had no job, paid no expenses. This is for 10 years, Your Honor. No expenses, no I mean, I guess Vipin had to pay for all the household expenses, the property taxes, all the maintenance. And that was the understanding with his brother for him being there as the tenant or authorized resident. Keyshawn paid none of these expenses. After 10 years, his father said, "Listen, you got to get a job. You got to move out." He's over 40 years old. Started asking him to move out. They signed an agreement which is our Exhibit 1, Your Honor, which Keyshawn agrees to move out on April 8th, 2023. In exchange for that, my client paid him $5,000 up front, is check number 340, and then says, "I'll pay you $50,000 after you move out to help you get on your feet."
I know your mouths have dropped.
This is a signed and notarized document, which is signed by both parties. And April 8th comes and goes. He doesn't move out. You're going to hear from us, Your Honor, if you want. We've got voicemails. We've got text messages from which he says he's going to be moving out. But
Well, I haven't gotten down into all of the weeds of watching the videos and listening to the text messages, but I have, or listening to voicemails rather. I spent several hours looking through the about 370 pages of documents that Mr. Potney submitted yesterday. I spent, in addition to that, reviewing the documentary evidence, which largely overlaps, right? I mean, a lot of the evidence is text message communication between the parties, the same police reports that I was provided, et cetera. So
Yeah.
I feel like I have some understanding
Okay.
of the very sad devolution, if that's the right word, of the relationship between these family members. But go ahead.
Unfortunately, and I'll get to my legal arguments in just a second. I just need to go through a couple points that were not brought out in the facts. But on April 13th, just 5 days after he was supposed to move out on April 8th, my client filed a dispossessory action. He filed in his personal name. And while the court recognized that you need to substitute parties and bring in the entity that owns it, my client did have a power of attorney from the entity giving my client full authorization. Now, Keyshawn's argument, which you've already heard, is that it was missing two witnesses' names. That is for a real estate. That's for a real estate power of attorney. So if I give you, Judge, the right to go close my house, I'm not in town. You've got to have this power of attorney with two real estate signatures. There's another power of attorney for healthcare as well, if you're going to act on someone's behalf for healthcare decisions. But for authorization to file a dispossessory, I do them all the time. Property management companies, this in the property management agreement, it's just a contract. So this power of attorney, you can call it whatever you want. It doesn't need these two signatures to go have authority to go and file a dispossessory. And that is where the dispossessory court did say you need to substitute names out.
Mhm.
But that's irrelevant here because he was evicted not by the dispossessory, but by the protective order. And so OCGA 1913-4, which, Shani, if you can bring it up, gives the court exclusive power in family violence cases to evict. And so, hold on, let the judge look at the top real quick. So at the very top, Judge, it says the court, upon filing a verified petition, grant any protective order or approve any consent agreement to bring about a cessation of acts of family violence. And it goes through their powers. And if you go to number 5, Dashani, it says order the eviction of a party from the residence or household or other assistance to the petitioner in returning it to the order of assistance in retrievable personal property. That's exactly what they did here. And Shawnee, if you can bring up the first TPO.
And that was actually going to be my next question. I think in the materials I was provided with some of those pleadings. One thing I was a little unclear on, though, is whether or not that TPO was made permanent by Judge Manning.
So yeah, I'm gonna get to two. So there was
All this is going to be blurred because all the information on there. But y'all cracking me up in the comments.
there was the first one, Your Honor, that is, if you go down to Section 8, this was the ex parte order. It says in Section 8, it gives sole and exclusive possession to my client of the property. Number 9 says the respondent is ordered to leave the family residence immediately. We go through and there's a second order that's entered after a hearing is held. And so, Sean, if you can pull that one up. And this one, it doesn't say, Judge, that this supersedes the first one. There's no language. So, in our opinion, that both of these are acting in concert. And if you go down, Ashani, if we go, it says the same thing. And number 7 is that my client has exclusive possession. He's also enjoined and restrained from coming around my client for 200 yards. Now, down at the very bottom, there is this language, Your Honor, that
12
says
months. Okay.
the terms of this order shall remain in effect for 12 months. And so there is that. But the first order didn't have that language. And so our argument is that this is still in place. If it's not in place, it the very least shows that he was removed from the property and he doesn't have a lease. There's no rights for him to come back to the property. But we also have testimony, his own voicemail that says he's leaving the property. So he's voluntarily relinquished his rights to the property. He doesn't come back at the end of 24 and say, hey, this TPO is over. I need to come back in. He files his lawsuit in 25. There's abandonment, there's waiver, there's all sorts of stuff. But Your Honor, the big thing is that the only agreement that we've seen is that March 6th agreement that says he's going to be out on April 8th. We've got this order that says he's going to be out. And he also we have a voicemail with him saying he's going to get out. So he's voluntarily released that. You don't need a writ of possession if someone voluntarily leaves. And that's exactly what happened here. He came back 6 times to get his stuff. So in terms of looking at your eyes, Your Honor, from success on the merits, that would be our first argument, that there is not going to be success on the merits for him to get back into the property solely because of that TPO removing him. But secondly, I think you've already noticed, Your Honor, he's got legal remedies here. Equitable relief is not needed here because at the end of the day, he can sue for whatever legal claims he wants for being wrongfully evicted. And that's typically how it's done, especially when there's not a lease. There's no lease here that gives him any rights to come back into the property. There's also, as you know, Your Honor, this is requiring affirmative relief from the court. Typically, as you know, equitable relief is to restrain activities. There are exceptions in which you can provide affirmative relief. But here he's essentially asking for almost specific performance of a lease. That's typically how wrongful tenants get back into a property. There is no lease. There's no specific performance. There's nothing. He's simply asking you to be the jury here and have this trial and award him, I guess, possession of the property. And when you start weighing the equities in the case, Your Honor, we've already heard that he disputes it, but there's an allegation he was thrown in jail for attacking my client. We've got the video, we've got the video recording of him saying that he's going to put a bullet in my client's head. That's why he got put in jail. And there's danger here. If you put him back to live with him, there is a very high likelihood of potentially physical damage to my client.
I know he did not say that to his father.
But also, we can go through all the threatening emails and voicemails. He's tried to damage my client's daughter by sending her employer information about this lawsuit, saying that she was going to miss work for being subpoenaed. He sent for the nephew, who's a lawyer with the Bird Law Firm, sent correspondence to those parties, trying in every way to try to damage my client and their family. He's jumped the gate before to come into the property after it's been locked. Um, this is not the type of relief in when you're weighing the equities, notwithstanding the legal issues that prevent him from being here. But there's one more legal argument we haven't really delved into, Your Honor. The dispossessory that was filed, he filed counterclaims in that dispossessory, which I actually just realized this a couple days ago that because I wasn't a part of that lawsuit. He filed a wrongful eviction counterclaims.
And they were dismissed.
Without prejudice. I
Yeah.
understand. He appealed. He didn't timely pay the bill costs. And the appeal was dismissed. What I wasn't aware of, which I just found out, is that he filed a separate complaint, a second complaint in that dispossessory action for wrongful eviction, which was also dismissed without prejudice. That would be the two dismissal rule, which we will brief in summary judgment, which he would not be able to bring this third action for wrongful eviction. So that would be another success in the merits that you would need to take under consideration, Your Honor. So therefore, Your Honor, we respectfully request that you deny this motion. We don't even need to go into the merits. Even if everything he says is true, he still doesn't get, we don't believe, a TRO or a preliminary injunction to move back into the property.
Somebody paid him big money. I didn't hear him say, not once.
Okay. Mr. Knight, a couple of questions before I hear from Mr. Potney. As I promised, I would let him have the last word. As I mentioned, your client has also asked for some injunctive relief here. And my review of it, I mean, certainly in litigation, the court has, quite frequently, at least typically, is in a position to order the parties to not have contact and, those sorts of things. But the nature and scope of what's requested in that interlocutory injunction, it really reads a lot more like a TPO, a family protective order, than it does like a typical litigation interlocutory injunction. And so one question I have is there some reason the court should reach out and address it in this case rather than if Mr. Bimji is concerned about the risk of violence, his simply pursuing another family protective order?
And that's a good point, Your Honor. And that's, one thing that we could certainly do is go back to the courts. But since this was already in front of you, and there were issues where Mr. Kashan was contacting my client directly in this case, is which I thought it might be relevant to bring it up because I asked him twice. I said, stop contacting my client directly. Didn't listen to us. And so therefore, since we were already in front of Your Honor, rather than going and initiating a new action, my client having to hire new lawyers because I don't do the family stuff, I thought it'd be more convenient to do that. And I think it's within your powers. And there's nothing, if you're balancing those equities, there's nothing that really hurts Kashan. I mean, not contacting his daughter's employers or not contacting, him directly. I don't think really there's a adverse hardship on him for that. Staying away, 500 yards. These were the same requirements that he had for years when the protective order was in place. I don't think that hurts him. So the requests that we're asking for, Judge, you're right. We could certainly go back, but I think it's well within your discretion to award that, given the nature of this case, I guess the fact that this is actually affecting me directly with him threatening my client, right after I told him not to. So that's where we would ask for Your Honor to rule on that motion as well.
Understood. Thank you, Mr. Knight. Anything else you want to add before I call on Mr. Potney?
No, Your Honor.
Okay. Mr. Potney, your response, sir.
All right. I do want to first clarify Mr. Knight's last statement. He said that I made contact with his client after he originally told me not to. I did not make contact with his client. I sent an email that CC'd Mr. Bimji by mistake. I even clarified it in the email stating, Mr. Knight, I'm not an attorney. I don't practice law every day. I was unaware that CCing Vipin Bimji on the same email that I sent to you and Mrs. Kumbar was a violation. It was a normal email. It had nothing to do with I don't know, any allegations that Mr. Brian and I just stated. It was a simple forwarding of an email that was sent to both parties. His response to me was, "I've already notified you once. Kindly refrain from contacting my client." It had nothing to do with anything that was just stated. And I can provide the email if you'd like.
Okay. I'm not sure exactly what I feel like the description Mr. Knight just gave me. Other than the added context that you have provided, that it was in the form of a CC on an email, that the descriptions are the same. That Mr. Knight indicated that you had he had advised you by email not to contact his client, and then you did something that Mr. Knight believed constituted contact with his client, and he advised you not to do it again. I think that's
Yeah, I'm
the
just saying,
same set of circumstances that I've heard from both sides.
it is, you're right. I'm just saying in the manner in which the narrative was told, it appears as though it was some sort of harassing communication, or when that was not the case.
Understood that it might not have been your intent for that communication to be harassing, but you understand that factually and legally, a communication doesn't have to be intended to be harassing to actually have the effect of being harassing, just so you understand that. But go
I
ahead,
understand.
Mr. Potney.
Secondly, going back to the beginning of what Mr. Brian Knight just stated, that his client had authority to initiate this possessory action. He has the documents. He's filed affidavits in the court stating that, or his attorneys have attested to, sworn in court, stating that he had managerial powers to initiate an eviction.
Mhm.
As I had mentioned right at the beginning, they provided documentation yesterday that has been withheld for since the beginning of this case. And if I can provide that to the court, it would show the nature of what I'm trying to say here.
Well, understand, Mr. Potney, if you show me those documents, you might be able to demonstrate that it's not properly witnessed. I think a couple of things are important here. Number one is that for purposes of your request, right now, I'm going to assume that everything you say is accurate, right? And what Mr. Knight's argument is that even if you are right, that it wasn't a properly witnessed document, or that Mr. Bimji didn't have authority, I asked you a question earlier before Mr. Knight started talking, which is that dispossessory was dismissed, right? You weren't dispossessed pursuant to any authority of a dispossessory action that was wrongly obtained through a power of attorney.
And I appealed it. The problem what happened was, let me just pause, just because I just want to just make a couple quick statements.
Sure.
This whole situation is very sad. This is my father.
It is. It's heartbreaking, and I'm an
It's
outsider.
and let me just this has nothing. This is no legal analysis, argument. Is highly unfortunate. The things that have transpired. With that being said, what was the original question that you just asked me? I'm sorry, I just got off.
No, that's okay. I had I think I've asked you a few questions that you have answered. Really, this was an opportunity to just sort of give you a last response.
Okay,
and you had started off by responding to a specific factual dispute that you wanted to take with something Mr. Knight had said.
Okay.
And now really it's sort of a wrap-up opportunity for you in terms of the relief that you're seeking.
So then Mr. Brian Knight stated that I filed an appeal, which was dismissed because I refused to pay the fee, the appeal fee.
Mm-hmm.
What happened was, at that time,
with respect, Mr. Potney, the fact that the appeal was dismissed doesn't really matter to today's outcome. And so right now, all I am aware of is that the record indicates that a bill of costs was issued and that it was not paid, and that as a matter of procedure, the appeal was dismissed. And the circumstances of why that happened are not really relevant to the court's determination today.
Got you.
Okay.
So basically, Your Honor, I haven't gone back to that property. All of my possessions remain in that property. Uh, Defendant initiated a civil action on April 13th.
Mm-hmm.
He locked me out from the residence on April 17th.
Mm-hmm.
I called Sandy Springs Police Department, having no idea that he had filed 2 police reports for assault battery.
Mm-hmm.
When they arrived to the residence, they notified me, and I said, who have I assaulted and battered? When was this filed? And why have I? Why has nobody contacted me? If you're making such a bold allegation that I've assaulted and battered somebody, um, they said you've assaulted and battered this individual on these 2 dates. He's filed police reports. I had no idea. They immediately took me to jail, and I had originally called them requesting their assistance in an illegal lockout. Mr. Bimji filed police reports that afternoon, then immediately put a lock and a chain around the gate, and then immediately drove to Fulton County Superior Court for a second TPO. The first one that he filed on April 14th was denied. All my possessions remain in that home, Your Honor. Since April, so he had me arrested on April 17th, as soon as I called the Sandy Springs Police Department. I've never slept in my own bed since that day. Every possession I own remains in that home.
So, Mr. Potney, I understand how frustrating this must be. I think part of what I'm a little confused about, though, is that the documents I have seen from both you and from Mr. Bimji indicate that you have been given multiple opportunities to go to the property and remove your belongings. And so I guess I'm not really sure why your belongings continue to be in the property if you've been given an opportunity to remove them.
I've been residing in hotels since April 17th, 2023.
Okay.
The home is about 10,000 square feet. My possessions probably would require about 3 of the biggest U-Hauls that you can imagine.
So you're saying you left some personal belongings there because there was nowhere for you to put them.
Majority of them.
Okay.
I'm not saying that I haven't, gathered possessions.
Mm-hmm.
I have. There's no doubt
Okay.
about it.
Thank you for that clarification. I appreciate that, Mr. Potney.
Absolutely. I have at the time I sold my vehicle after to pay my attorney fees at the time when he had initiated this dispossessory action.
Mr. Potney, forgive me for interrupting you. And this is one of those things where I know it can be very frustrating for a non-attorney because, you're in front of a judge, you're in a hearing, you want to tell me your entire story and help me understand why you're taking the position that you are taking. And I understand that instinct. But today isn't really it's not the proper vehicle or time for it. And here's why. The only thing the court is being asked to do right now is to determine whether there's some temporary relief the court needs to impose while this lawsuit goes on. And while it is helpful, and I do appreciate the parties providing me with this background, all of these documents, because I've had an opportunity to review them, I think it is, I feel like I have some understanding of what happened in terms of what started happening in April and then how we got to where we are now. And so I do want to ask you one last question, Mr. Potney, and that is, you have mentioned that you still have, don't have some of your possessions, that you've not been back to the property. One of the things that was asked of me by Mr. Bimji is to limit your ability to go to the property or to have contact with Mr. Bimji. If the court were to order that you not have any contact with Mr. Bimji, do you understand that limitation? Would you be willing and able to comply with that limitation?
I would.
Okay.
I would. It's not the first time that he's done it.
Okay. Mr. Potney, if you have any last messages you want to share with me, any last points you want to make, this would be your opportunity to do so.
Sure. Your Honor, I understand that there's not a very good likelihood that me and Mr. Bimji would mesh well in the same household. I understand that. It's, you know, he's filed restraining orders against me. He's seeking another restraining order. I fully understand that. I do not want to be in a home with someone that doesn't want me to be there. I fully get that. At the time that I filed this emergency order for relief, um, because Mr. Bimji had continued to lock me out of the residence, he had been paying my rent. And at the time, I initiated a federal lawsuit, which is still ongoing. His nephew called him and said, you know, this guy's filed a lawsuit naming me as a defendant, as a state, as a state actor. He's terminated all my finances. After having me arrested, I've been unable to obtain employment. And I was going to be I immediately became homeless. I no longer reside in the state of Georgia anymore. I had to relocate to Alabama to live with the same people that saved my animal, one of my dogs. One of them was euthanized.
I'm very sorry, Mr. Potney. You, I think, correctly pointed out that this is a very sad set of circumstances. It really is. And, you know, I wish that there was a magic wand that any court could wave and make this not be the way it is and make the family able to reconcile. But unfortunately, the court doesn't have that ability or authority. And ultimately, all I can do is deal with the legal requests that are in front of me. And so here is what my ruling is going to be. I am going to deny the plaintiff's request for a temporary restraining order for two reasons. Number one, I think I'm concerned that Mr. Potney will not be able to demonstrate success on the merits of the underlying claims, number one. And number two, to the extent he could demonstrate success on the merits, he has an adequate legal remedy in the form of damage to personality and damages associated with his wrongful eviction. His alleged wrongful eviction. And so because of that, I don't believe that interlocutory relief is appropriate or necessary in this case in favor of Mr. Potney. As I noted a moment ago, Mr. Bimji has also requested injunctive relief. And the reason I asked Mr. Knight about whether there was a different type of relief that might be more appropriate here, it's mostly because I think the type of relief that I would grant would be much more limited in scope than anything that a family protective order might impose, because there is a different caliber of evidence and nature of allegation that is made in the context of a family protective order. What I will do is enter an order that, just to be clear, takes effect right now, even though I need to reduce this to writing, which is that Mr. Potney should not be contacting Mr. Bimji or the individuals that are in possession or ownership of the house related to this lawsuit. Now, I understand that there are others that Mr. Potney has contacted, or who Mr. Potney has contacted people about those other individuals. I question whether that is helpful to Mr. Potney's case and position, but I also question my authority to expand the scope beyond really the parties to this case and the property at issue in the case in terms of limiting anyone's ability to communicate. What I will say is the same thing I say when I'm entering non-contact orders, which is that non-contact means direct or indirect. It means social media. It means by phone. It means through third parties. If the intention is to communicate a message to the party that I have forbidden contact between, then it would potentially be a violation of the order. And to be clear, the order that I'm going to enter is that for the duration of this lawsuit, Mr. Potney is not supposed to have direct communication or contact and Mr. Potney is prohibited from having indirect communication or contact with Mr. Bimji, with Ms. Potney, who I understand to be Mr. Bimji's wife, and Mr. Kishan Potney's mother, and the company that owns the property. Because those are, I think, the relevant parties in this action, and encourage everyone from refraining from ongoing communication or contact, because I think that the only thing that happens from that is that people's emotions get dialed up, and then people get upset, and it leads to people not being able to try to rationally address what the legal and factual issues are in the case, because everyone is emotionally invested, which I think is hard to avoid when you're talking about family members. That is going to be my entire ruling for today. I did want to sort of make sure we were all on the same page in terms of the procedural posture of the case. The case has actually been going on for a bit. And what I would typically do, different judges manage their dockets in different ways, but it seems as if the parties, there was an answer filed in December, and it seems as if the parties have started. Mr. Potney's mentioned that there was some discovery served, and that discovery has been responded to. So it sounds as if the parties are attempting to engage in that discovery process. What you can expect is that in about 3 months or so, the court will likely be looking to place this matter on a trial calendar, unless there is additional procedural matters that need to be addressed. I may very well enter a scheduling order that just makes clear that there is a 6-month discovery period that's been allotted for running from the time of the answer. So that would get you to about June. And then if there's motion practice, that we'd be looking at about August. And then if you're talking about trial, we'd be looking at September, October. That's what I expect would play out in a scheduling order that I would enter. Any questions, concerns about entering a scheduling order or setting the matter for trial and the continued discovery? Mr. Potney?
No, ma'am. No, Your Honor.
Mr. Knight?
No, you're on the scheduled order, but I do have some points of clarification on
Yes, sir.
your order, and I do want to at least perfect the record with a couple exhibits for this matter in case there is an appeal on from Mr. Potney.
Okay.
So points of clarification. Does your order, can your order also include Mr. Vipin's daughter, Kishan's sister, who he contacted her employer about this? Can you, regarding the communications directly or indirectly?
Does she live in the property?
She used to. Does she anymore, Ashani?
She does not.
Okay. She
And
did previously.
I guess my question is, what was the nature of the contact?
So the contact, he sent some kind of letter or email to her employer saying that she's going to be missing a lot of work coming up because he's going to subpoena her for this lawsuit that she's in, all this kind of stuff.
That's incorrect, Your Honor.
No, hang on, Mr. Potney.
I can show you that. If you want to see the email, I can show it to you. Here you go, Shawnee. Show the judge.
Thank you. So here's my concern, but you can take down the screen share. I understand.
Okay.
Here's my concern. While that communication on its face is unkind and probably ill-advised, Ms. Potney, I believe, the sister that you're referring to, is not a party in the case. And while it might be characterized that that is indirect contact ultimately with the owners and possessors of the property, I'm concerned about ordering Mr. Potney to have no contact with individuals who are not directly before the court. And that's why I mentioned that sort of it going beyond the scope of what the court would typically do. I would just remind the parties that whether you are an attorney or not an attorney, that communications with witnesses and in cases should generally be respectful, and should not be harassing. But I understand your concern, Mr. Knight, but I have reservations because that individual is not a party.
Oh, I understand, Judge. The next thing is, I think you addressed it with Mr. Kashan about staying away from the property. My
Yes.
client does have serious concerns because this gate can be jumped over. He's already done it once about just staying the 500 feet away from him. He said he didn't have a problem with that.
Okay.
Could you also include that in your order, Your Honor?
I am willing to include that, Mr. Knight.
All right, thank you, Your Honor. And then lastly, just to perfect the record, Your Honor, just to uphold, in case he tries to appeal your denial, which is very difficult, but I do want to at least get this into the record. Did the court take judicial notice of all the orders that were referenced in our exhibits? These are strictly from Superior Court of Fulton and State Court of Fulton. Just take judicial notice of those and enter those as part of the record.
Yes, and although I didn't say the magic words of judicial notice, the fact that I referenced them a number of times and indicated, I mean, obviously the court has access to the full docket of cases that are filed into the Fulton County courts, and the parties had provided me with that information. And so, yes, although I didn't say the magic words of judicial notice, I did in fact judicially notice the information that was in those dockets from everyone's perspective, both documents that Mr. Potney had filed in, as well as documents that Mr. Bimji had directed the court's attention to, as well as the orders that were entered by those courts.
Perfect. Thank you, Your Honor.
Okay. Mr. Knight, if you would please provide me with a proposed order that reflects the court's ruling here today. Again, to be clear, my ruling takes effect now. It is my intention to enter a written order as soon as one can be provided to me, and then I will edit it to the extent that I see necessary. But beyond that, that's going to be the ruling. And then what I will do also is, as I said, enter a scheduling order, or take some, it will be an abbreviated scheduling order that says discovery is ongoing. And so discovery will end on X date. There will be dispositive motions deadline on X date. And then there will be a trial calendar in this month. Beyond that, anything else the parties need me to address? Mr. Potney?
No, Your Honor.
Mr. Knight?
There's one last thing Ms. Kumbar reminded me. We've asked in discovery for Mr. Kashan's address because we want to send a offer of judgment. We have to send it via FedEx pursuant to the statute 91168. We've not provided an address. The address he lists in the complaint is the 50 Point Ridge address. I was going to cross-examine him and ask him for his address, but I would ask the court, can we at least get his current address so that we know? Typically, you put it on the pleadings, but we have not seen the address.
I thought I saw an address on
Francis Street.
Francis Street in some of the filings here in Atlanta.
Okay. Well,
is that an address? Hang on, Mr. Knight. Mr. Potney, is that an address where you are authorized to receive mail?
Yes, ma'am.
Okay. And do you mind providing that address, or at least authorizing them to mail you whatever they want to mail you by FedEx at that address that's in some of the pleading documents?
Yeah, it's on the pleadings.
Okay.
1268 Francis Street.
The problem we're going to have with the 91168 judge is that we have to send it via FedEx or certified mail, and if he doesn't sign for it, if he's not there, he just said he lives in Alabama. This is the problem that I'm having, is that I could have a service problem if he's not at the actual address. So can we have his address where he's currently residing in Alabama?
Mr. Potney, do you mind providing that?
Can I object to that?
Well, that was my question. Do you mind providing it? Sounds like the answer is yes.
I do.
Tell me why you mind providing it.
For security reasons. The last, like some of the things that you've heard about. The last time that Defendant Bimji had my hotel address, he had my dogs euthanized, taken from there, and he had me arrested. And for those reasons, I'm concerned for my own safety.
Well, to answer the question in the chat, if you're at a hotel long term, you can have mail delivered there.
Well, I understand the limitations that you're operating under, Mr. Knight, but if generally speaking, if he's provided an address in the pleadings, I think you have to take whatever reasonable steps you can to try and provide it to him at that address. I don't know that address in Alabama is anything other than a transient residence. And if he's indicated that he is authorized to receive mail and contact at that Francis Street address, which is the one he has provided in the pleadings, I think you have to go with that one and see what you can see if you can accomplish it that way.
Fair. Thank you, Your Honor.
Thank you all. Have a good day.
I didn't realize I was mute. Yeah, so all I was saying was that it's a shame that he went against his dad like that. And but as you heard, the dad cut him off with funds too. So he gonna have to figure that stuff out. But they may end up coming back to court again on a trial or something like that. Don't know. But I'll send y'all off like I normally do with a little something here at the end. And yeah, if you enjoyed the video, just give it a thumbs up before y'all leave or when you on your way out. Hold on.
He came in hot saying I was locked outside. Talking wrongful eviction, said they killed his rights. Said the chain on the gate and the locks got changed. But the judge looked back like, let's get this straight. No lease, no rent, now the room gets still. One hard question cut against his will. You can call it a lockout, call it unfair, but prove to this court you belonged in there. This lockout claim got put to the test. Big accusation, but the proof looks stressed. He kept saying, wrongful, judge said maybe then. Show me the right that lets you back in. Family ties turn cold in a courtroom fight. Years in the house, now everything's spied. He wanted back in, wanted damages too, but the bench kept pressing what the law would do. When the story gets loud, but the record gets thin, one question can break what the claim came in with. This lockout claim got put to the test. Big accusation, but the proof looks stressed. He kept saying, wrongful, judge said maybe then. Show me the right that lets you back in.
There it is. Let me clear that. All right. Thank everyone for hanging out. I appreciate everyone that was here. Thank you, Marge, for helping out. And I'll see if I have something for y'all tomorrow night. All right. So I hope you enjoyed everything and see you next time.